Going to talk about typical proceedings interpreted by certified court interpreters. You're not going to see this in your manual. This is an explanation of certain proceedings and with vocabulary that I find very helpful because in your class, in Criminal 2, we go over some of these proceedings. So I like to explain to you some of the typical ones that we do in court. So after this 45-minute to 50-minute explanation, you should have an idea of what an interpreter does in a criminal court anywhere in the States on a daily basis. There are some exceptions that sometimes the interpreters have to do proceedings that occur occasionally, not every single day. But if you're looking at a typical day, and that's the key word, typical day, it's whatever I'm going to be talking about right now. Now, we do know that we do arraignments, and you have extensive training on that. The whole class has been going through arraignments, and that's not very complicated, very straightforward, simultaneous component is used. And the arraignments are basically the only thing that really changes are the different crimes, the dates, the names of the individual charged, the amount of bail set by the judge, and the next date that the defendant has to come back. And those are pretty straightforward. So they are, we're not too concerned about that. So they're not new to you. Now, the other one that you will be interpreting in, and those are typical, right, is pretrial hearings, remember? And that's also in your book. We already talk about it. It's nothing else than you interpreting for the attorney and the defendant. When the attorney for the defendant conveys an offer to the defendant that was given by the prosecutor in a case. So the whole purpose of a pretrial hearing is to settle a case so that the case is basically over that day. To settle a case, resolver la causa. Remember that? And then the type of conversation that occurs between the attorney and the defendant has to do specifically with the offer given. And the typical offer is, 6 months in county jail, 3-year probation, attend a program, whatever it is, drug program. And we did mention that drug program no es programa de drogas, for Christ's sake, because that implies in Spanish that you're learning how to use drugs. Es programa en contra de las drogas o programa para drogadictos. Now, I strongly suggest in court you don't use programa para drogadictos because usually the drug addicts are the last one to admit that they are addicts. So when you tell somebody, usted tiene que asistir a un programa para drogadictos, they look at you and say, yo no soy drogadicto. Then you have to interpret that, I'm not a drug addict. And then it creates this unnecessary exchange between the judge and the defendant that really interferes with the flow of the proceeding. So, and that's because you decided to use one interpretation that you know that it could create a problem, okay? And then there is also the cross-cultural issue there. Even though you're only interpreting for the defendant, in our culture, sometimes it's sort of taboo to say that you are a drug addict. So it's sort of out of respecting the defendant's privacy or his feelings, because the cross-cultural issues are very important also in interpreting, and we will see that in criminal too. But yeah, so why not pick a term that is programa en contra de las drogas? So it's very impersonal. You're not really talking about an individual. So that should be the transfer. And the same thing with alcohol program, programa en contra del alcohol. We don't want to use programa para alcohólicos, obviously, because sometimes that could create some problems. All right, so that's the pretrial hearing. Now, the next one that we do on a daily basis is a type of hearing that we have not been exposed to here at all. And remember, in a pretrial hearing, one of the items in the offer is probation. Remember, that's typically the way it is. So you'll be on probation for 3 years. Now, probation, libertad a prueba, libertad condicional, condena condicional, these are all correct translations. Régimen de la condena condicional, that's also correct. Probation, when the judge puts a defendant on probation for 3 years, the case is not officially over. And and this is an important thing to keep in mind, because remember, judges have to justify to the judicial council how many cases that judge completed in a given year. There is a number of cases they have to finish in general. So if the person is placed on 3 years, you can't really claim that that case is over until the 3-year probationary period ends. And that's an important thing, because that plays on the mind of the judge, and you will understand why I mentioned this and I emphasize this. Now, do you remember that probation had certain terms and conditions? And typically what it is, you will see this in criminal 1, but when the defendant decides to accept the offer, all right, the judge is going to sentence the defendant, and the sentence will probably be something like this. Imposition of sentence is suspended for 36 months under the following terms and conditions. We're going to see that. La imposición de la condena, imposition of sentence, is suspended, queda suspendida, o queda en suspenso, for the following 36 months, durante los siguientes 36 meses, under the following terms and conditions, bajo los siguientes términos y condiciones. And then the first term or condition is that the defendant serves jail time. Now, do you recall when we talk about in pretrial hearing that defendants accept probation because the amount of jail time is decreased when you're on probation, right? And I remember that I told you, if I commit a crime and I get an offer, my attorney will probably say, look, the crime you committed calls for 6 months in county jail. But the prosecutor is offering only 1 month and probation for 3 years. So what that means is that I should really go to jail 6 months, but I'm going only 1 month. Those 5-month difference that occurs here is something that the judge can play with when you do not do or when you violate any of the terms and conditions of your probation in the future. So if I am placed, and that's why the wording is in position of sentence, because see, I'm not really sentenced yet. I should go 6 months to jail. So in position of sentence is suspended for 36 months under the following terms and conditions. So if I'm supposed to get 6 months, but I got 3-year probation, and I know it's 3, in position of sentence is suspended for 36 months. Had it been for 24 months, then the probationary period would have been 2 years. Is that clear? Okay. And then the first term and condition is going to be the jail time that I have to serve. Because they don't want to send you, technically they don't want to send you to jail necessarily, but the prosecutor will give you some time in jail so that you get a feeling of what it is, so that you don't want to be there again, and therefore you're gonna comply with all the terms and conditions of your probation. That's the logic that they use. It doesn't necessarily happen that way. So, in position of sentence is suspended for 36 months under the following terms and conditions: that the defendant serves 1 month in county jail. That's the first term. That the defendant attends a 18-month drug program. That's another possibility. Que asista a un programa, you can say un programa en contra de las drogas, un programa de rehabilitación para drogadictos. I don't suggest, as we discussed earlier, that will be a good one. But it is que el acusado asista a un programa en contra de las drogas de 18 meses. Then the next condition, that the defendant pays a restitution fine. Do you remember restitution fine? Multa de resarcimiento, no restitución, resarcimiento of $390. That can change the amount. That the defendant comes to court for a progress report. Do you remember in the offer for pretrial hearing that one of the items in the offer was that the defendant had to come to court for a progress report, un informe evolutivo, progress report, informe evolutivo? And the other thing is that the defendant obeys all laws. So if you look at the offer in your manual from pretrial hearings, and you look at the way the judge sentences the defendant, they match. The only thing is that the judge uses different terms than what you see on your pretrial hearing, because After all, in the pretrial hearing, it's just only the offer that is conveyed to the defendant. But the judge will say, the imposition of sentence is suspended for 36 months under the following terms and conditions. The defendant is to serve 1 month in county jail. Now, at that time, at that precise moment, the judge wants to know if the defendant has been in jail or not. Because, the defendants get arrested, then they show up in an arraignment, which occurs a few days later after they are arrested. And then there is bail that is set, remember? If bail was paid or deposited or posted, really, that's the term, by the defendant or the defendant's family, then the defendant is out. But still the defendant served 2, 3, 4 days. But if bail is not posted, then the defendant is in for a while, maybe a month. So the judge will say, the imposition of sentence is suspended for 36 months under the following terms and conditions, that the defendant serves 1 month in county jail. And then the judge will look at the defense attorney and will say the following question. Will say credit, and then you will say, and the interpretation will be is, ¿qué crédito tiene? And that refers really to crédito de días, no de dinero. Okay? And then the attorney for the defense will answer as follows. 6 actual, 3 good time, work time. What the attorney is saying is that he was in jail 6 days. So that's why he has 6 actual days. In Spanish, we'd say 6 días efectivos. Efectivos. That's the translation for actuals, actual days. So 6 actual, they don't even say days. So you'll say 6 días efectivos. 3 work time, good time. This 3 is what is known as the credit, the extra credit that they get for being in jail and for being, for basically for good time or work time. One or the other, not both. Usually this number is half of the actual number of days. It's 50%. So if a defendant serves 10 days in jail, he's actually serving 15 days towards the sentence. Plus, there might be additional credit given by the sheriff department because of overpopulation or whatever the case. And that depends on the season. So maybe currently here in Los Angeles, 1 month means 6, 7 days, and that's enough because of all the credit that they get. Okay? But maybe if they were to build many more jailhouses, maybe that will not be the case. Now, this idea of this credit stuff doesn't occur in state prison. State prison, 1 year is 1 year. But you get the possibility of getting parole. Remember that we talk about that? Libertad preparatoria. And that is something that you can only request after you serve 2/3 of your sentence. So if the time was 9 years, you can start requesting parole year number 6, number 7, but you may not get it. That's the only possible way of serving less time than what you were sentenced. Now, it's something I want you to remember for criminal 2, that in state prison, no credit, no extra credit like that. County jail, lots of credit. Now, you know what is the maximum time that a defendant serves in county jail for a misdemeanor? 365 days, 1 whole year. Do you know what's the minimum time the defendant will serve in state prison? A year, 365 days. So I pose this question to all of you. Let's see if we can make some of you attorneys here. Say, for example, that I'm charged with a felony, because if I go to state prison, it's a felony. And the punishment is 1 year in state prison. Can you, as my attorney, request that that year be served in county jail? It just happens to match.
No, because it's a felony.
Yes, you can. And with a good attorney, what's going to happen is that The attorney is going to say, you know, can he serve that year in county jail? Of course, the prosecutor knows that 1 year in county jail might be only 3 months. So what the prosecutor is going to say, okay, that's fine, but we're going to put him on felony probation. Now, felony probation, in Spanish translates as libertad a prueba, if you like to use that term for probation, supervisada. It's different than the probation you get in these misdemeanor cases where you don't have to report to anybody. For a felony probation, you have to report to a probation officer and tell the probation officer what you're doing, you know, what your whereabouts are. You know, that's actually the way it works, among other things, whether you change your address. Pardon me? It's called formal or felony probation, exactly. It's the same, you studied formal probation already, right? Same thing. It's known as felony probation or formal probation. Okay, so it's important to keep that in mind for criminal too, because we're going to look at cases where because some people say, wait a minute, how can you have probation for somebody that committed a felony when you're telling me that probation is always for misdemeanors? Not in this case. This is a different case. If you just decide, if you're given the opportunity to serve time in county jail instead of state prison, you will be under formal probation or felony probation, libertad a prueba supervisada. The other one, for the regular one for misdemeanor, is known as what? Summary probation. Did you study that one? No. Okay, so I'm going to write it down. Summary probation. And summary probation is libertad a prueba. What do you think it is? No supervisada. Remember, the judge says imposition of sentence is suspended for 36 months under the following terms and conditions. That you serve 1 month in county jail, credit, and the attorney says 6 actual, 3 good time, work time. I haven't given you the translation of good time, work time. I will do that in a second. And then all the other conditions. But at the very end, the judge says you obey all laws. At no time the judge says you have to report to a probation officer. Okay? Now, that's going to be very important information in criminal too. Now, what is this good time, work time? Now, here is the linguistic transfer of this is por buen comportamiento o trabajo en la cárcel. So I'm going to give you that in a second, but then I'm going to also discuss with you what's the best option, because this one can be a problem, this translation. Good time / work time. The proper linguistic translation is por buen comportamiento o trabajo en la cárcel. Now that's the linguistic translation, but in real life, this is what occurs. You're interpreting for the defendant. The judge says imposition of sentence, blah, blah, blah. Defendant is to serve 1 year in 1 month in county jail, and it says credit, and the attorney says 6 actual, 3 good time, work time. And when you say 6 días efectivos y 3 días por buen comportamiento, trabajo en la cárcel, the defendant automatically looks at you and said, yo no trabajé en la cárcel. Because it's one or the other. But they don't register the o. Por buen comportamiento o por trabajo en la cárcel. They register trabajo en la cárcel. And they want to make sure that they know. So then you're going to have, you have to interrupt the flow again. Then when the defendant says that, you have to say, I didn't work in jail. And then the judge is going to look at you and say, what are you talking about, right? So it's always preferable to say, 3 días por buen comportamiento, porque comportarse se comportaron todos bien. Así que cuando dice uno trabajo en la cárcel, excluye a mucha gente. Pero cuando dice por buen comportamiento, todos piensan que se comportaron bien. So you won't have that problem. That's just to continue the flow, okay? What you don't want is disrupt the flow in a courtroom, okay? Now, but if you were to take an exam, interpreting exam, you have to provide the translation that I gave you earlier, which is por buen comportamiento o trabajo en la cárcel. Now, remember one of the conditions was to attend an 18-month drug program? Okay, what is that? Well, the defendant has to go to a program for 18 months, maybe 1 hour a week or whatever the case is, and there's going to be in that program somebody who's going to do what? It's going to be teaching the program, a counselor most likely, and every 6 months, because the defendant has to come to court for a progress report, para un informe evolutivo. Remember, progress report, informe evolutivo. Let me write it for you, just dip. Informe evolutivo. That's a progress report. Every 6 months, you have to show up in court, and basically the judge receives right before this case, or right before they call the case, the judge calls the case, receives a report, like a couple of days before, from that person in charge of that program, and says, Mr. Rodriguez has successfully attended blah, 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 blah. So a progress report is nothing else than the defendant showing up and the judge basically reading the report, and the judge telling the defendant, oh, keep up the good work. Come back in 6 months or 3 months. But there are possibilities where the defendant is not doing what he or she was supposed to do, attending regularly, participating, whatever. So the report will so indicate. And the judge may say something like this: Mr. Rodriguez, I just received a progress report, un informe evolutivo, from your counselor. Counselor will be what? No es abogado. This talks about a counselor in the drug program. Okay, some people use consejero. That's it. Consejero. What else can you say? Terapeuta. No, we can't say terapeuta. We can't say psicólogo because it may not be. Counseling is always, the generic translation for counseling is ayuda profesional. That's the best translation. But when you refer to a counselor, you can say consejero, you can say terapeuta. That's okay. Okay? Now, so so the judge will say, I received the report from a counselor, and you're interpreting all that. And it shows that you're not, it indicates that you're not showing up. Mr. Rodriguez, do you remember that we gave you probation for 3 years, and one of the terms and conditions was that you completed an 18-month drug program? You're not completing it right now. So I'm going to give you a last chance. I'm going to ask you to come back in 3 months. If in 3 months I receive a report similar to this one or worse than this one, make sure you bring your toothbrush, because I am going to impose the remaining time that is pending. What's the remaining time? Exactamente, el tiempo que le falta, el tiempo pendiente, o el plazo will be better, el plazo que le falta, el plazo carcelario pendiente. And that is how much in this case, what would be that time in this case? Well, it's 6 months is what I was supposed to serve, but I am asked to serve only 1 month because I'm on probation for 3 years. If I'm not doing anything for whatever the probation, I violate any of the terms and conditions of my probation, the judge can impose the difference between that, 6 minus 1, 5 months. The judge can impose 10 days, 1 day, 0 days, 5 months, 4 months. It's up to the judge. Okay? Now, that proceeding is called progress report, and we do a lot of those. So besides arraignment, besides pretrial, we also do progress reports. Now, there is also another proceeding that we'll do that is called probation violation hearings. And before I even discuss this, there is an expression used a lot in progress reports that I want you to know, and that is, I will max you out. When a judge tells a defendant, if you don't do that program, I'll max you out, it means I'll give you the maximum punishment. And in the example I just used before, what is the maximum punishment? Well, 6 months minus 1 is 5 months. So in Spanish, we translate this as le impondré la sanción máxima. I'll max you out. Okay? So, now let's look at probation violation hearings now. Now, what is a probation violation hearing? By the way, I know that the examiner is waiting for you for the one-on-one session, but I don't want you to go there until we finish here. It will be another 10 minutes or so, okay? I know that you're anxious to have your one-on-one evaluation with the examiner, but we're going to wait 10 minutes. I really want you to learn this. Probation violation hearing, when does that occur? Anybody? Exactly, when a person violates the probation. First term that we have to look at is violation. We know that violation is what? Okay. No. Quebranto, but only when we talk about what? A section, right? Okay. Okay, let's look at all the possibilities. Violación in Spanish is used, believe it or not, when it is not specific, exactly. When you violate rights, when you violate the laws, when you're not specific. So it's non-specific. What does it mean? If I tell you you violated the penal code, you can say violó el Código Penal. But as soon as I tell you violated section 15, which I'm very specific, then you have to use quebranto. And then there's another one, incumplimiento, which means no cumplir. And what does that mean when we say incumplimiento? Where does that come from? Well, if you remember, or you may or may not remember this, but when two people get into some type of an agreement, and one doesn't breaches that agreement, we say no cumplió o incumplió con el acuerdo. Well, probation is an agreement between the judge and the defendant. So whenever you use probation or parole, for probation or parole, you will use incumplimiento. So probation violation hearing es una audiencia por un incumplimiento de la libertad a prueba. Audiencia por un incumplimiento de la libertad condicional, libertad a prueba. We have various options for probation. Now, what about if I say you violated your probation? How would you say that? No, it's probation. We can use quebrantó. Incumplió o no cumplió, right? So you violated your probation. Usted no cumplió con su libertad a prueba, okay? Now, we do hearings. Now, let's look at a typical probation violation hearing, and we finish with this. When does it occur? When you violate probation. Well, if the condition is to serve 1 month in jail, that one you're not going to violate. They're going to take you and you're going to serve the 1 month in jail. Attend the program, 18-month program. That's a possibility. Let's say that you do attend the 18-month program. Pay a restitution fine. It's very rarely they're going to lock you up because you don't have money. All you have to do is tell the judge, show up when you're supposed to pay and say, I don't have money, give me more time. So that's probably not going to be the case. Appear and come back for a progress report, you probably will show up. Because if you went to the program, you're going to show up. You know the judge is going to tell you, oh, you're doing a great job and all that stuff. And people like to hear that. But the last one is obey all laws. Say, for example, that in 2014, I was given probation for 3 years. In 2014. And in 2015, I now drive under the influence of alcohol. So I have this new case. So I go to court for that new case. And they give me an offer for that case. And I like the offer. So I take the offer. So I tell the judge that I'm guilty. When I told the judge that I'm guilty of that crime, I automatically did not obey all laws in my probationary period, right? Because in 2014, I agreed to obey all laws for 3 years. But now in 2015, I'm saying that I'm guilty. That's the typical probation violation hearing. How can I go out to and of course, I will, if the offer is 2 days in jail, just to give you an example, after I serve the 2 days, they're going to take me back to the judge from the 2014 case. And that judge is going to look at me and say, look, remember you were supposed to serve 6 months in county jail? Yes, Your Honor. And we gave you only 1 month and 3 year probation? Yes, Your Honor. And one of the conditions was that you obey all laws. Yes, Your Honor. So, but a year later, you drove under the influence of alcohol. Yes, Your Honor. How can I defend myself in this case when I went to the other court in 2015, today or a few days before this proceeding took place? I went to that judge and I basically told the judge, I'm guilty. So what is going to happen in that probation violation hearing is that I will have to admit the violation. To admit the violation. Aceptar. What? To admit the violation is el incumplimiento, right? El incumplimiento. So the judge will say, Mr. Rodriguez, or in this case, Mr. Wagner, do you admit that you violated probation? ¿Acepta usted que no cumplió o que incumplió con su libertad a prueba? And I admit. And then the judge is going to have to sentence me. What's in this example where 6 months was the maximum and I served 1 month, what's the maximum punishment that I can get? 5 months. The first thing, that there are many different type of punishments, okay? But the typical one, because the jails are overcrowded, is not to send the defendant to jail. However, the judge is now thinking, wait a minute, now I have this guy, have this case that I cannot claim as being settled yet, because it's not settled really, it's not resolved. I still have this guy on probation. I probably would like to max him out so I can finish with this case in about 2 months. He's 5 more months, he's going to serve a month and a half, I'm done. This is done. I don't have to have this person come back to court every time and basically have a very heavy calendar because of all these people that are not doing what they're supposed to do. So there are judges who will max me out. But most judges the punishment will be either a few days in jail, but it will be to sort of revoke the probation, the initial one, and to reinstate it again, but now it starts again from zero. The clock starts now instead of 2014. Now it starts in 2015 for 3 years. So if I had obeyed all laws, I would have been over in 2017. But now, because of this, I will be over in 2018. So the phrase that you hear a lot is probation is revoked, period. And then suddenly it says probation is reinstated under the following terms and conditions. I will give you the interpretation in a second, okay? Now, here's where the judge may punish me. And the way it works is as follows. The judge will say probation is revoked. Probation is reinstated for 36 months. Sometimes they put the dates there. So it should be there. Probation is reinstated for 36 months. If they don't say it, it's the same probationary period that was initially agreed on. So if I don't say it in this case, it's still 36 months. So probation is revoked, probation is reinstated for 36 months under the following terms and conditions. And now here's the punishment. That you serve 10 days in county jail. And then the same conditions that you had before. Attend the program and all that. But now there is a new condition. Serve time. And judges will tell you at the end, will say, Mr. Wagner, I'm sending you 10 days in county jail, so it appears that you have forgotten what it is to be in county jail. I want to make sure you remember, because next time I won't revoke and reinstate it. I will max you out. Okay, is that clear? All right, so what's the transfer of this, and then we'll finish. La libertad a prueba queda revocada. I like to say la libertad a prueba original queda revocada, because otherwise it's a little bit confusing. But linguistically, it doesn't say the original probation. So for a state exam, I want you to use this. In real life, sometimes you have to add a word here and there so that it makes sense. Because when I say somebody, la libertad a prueba queda revocada, and then the next phrase I'm saying is, la libertad a prueba se otorga nuevamente, what the hell's going on? What it really means is, la libertad a prueba original queda revocada. Una nueva libertad a prueba se le otorga bajo los siguientes términos y condiciones. That will be much more the message is better, it flows better. But from a linguistic point of view, or the transfer actually, I should say, you have to transfer this based on what you hear, which means la libertad a prueba queda revocada. Okay? And then the next part is la libertad a prueba, libertad a prueba, se otorga nuevamente. Bajo los siguientes términos y condiciones. And then the terms and conditions will be the same, with an additional punishment, additional time in jail. In real life, I usually like to say, la libertad a prueba original queda revocada. Se le otorga una nueva libertad a prueba bajo los siguientes términos y condiciones. Los siguientes términos y condiciones. Okay, so it's up to you what you. But for the exam, I don't want you to add things, because in the exam they may say, oh, you're adding or this or that. God knows what they think. Really, the message is the same. In fact, the message is clarified by that addition. So we're going to stick to just the transfer of words more than anything else. And that will be, la libertad a prueba queda revocada, la libertad a prueba se otorga nuevamente bajo los siguientes términos y condiciones. If it says probation is reinstated for 36 months, you will say la libertad a prueba se otorga nuevamente por 36 meses bajo los siguientes términos y condiciones. Okay, so the typical proceedings we do in court, just to wrap this up: arraignment, which you already know; pretrial hearings, which you already know; probation violation hearings, which are known as PV hearings. If you see PV hearing is probation violation hearing, which now you have some idea about it; and progress reports. And then there's traffic, tickets that you will have to interpret in traffic, but just a few. Traffic is not, they are not misdemeanor or felonies, and they are very specific, and we see that actually in criminal too. We have a session only in traffic court. But traffic is pretty straightforward. I'm not that concerned. And technically, defendants are not guaranteed, they don't have a constitutional right to get an interpreter in a traffic case, because the only time they have a constitutional right to have an interpreter is when jail time is a factor. The same way that the people that get a ticket don't have a constitutional right to have an attorney, they don't have a constitutional right to have an interpreter. But all courts provide interpreters for that. So we're going to see that separately in criminal too. All right, so this ends the presentation on a typical day of a court interpreter. Thank you. Okay.